A lot of adults today walk around with smartphones, what's 500, 1 million, and so on. Yet, and they insure that smartphone, those gadgets that they are holding. Yet, there is no legal document protecting their life, properties, or even their health and families. Let's talk about this legal preparedness document every adult should have before it is too late. That is the topic we'll be discussing today. I am your host, Gloria. Welcome to Serenity TV, where we discuss real life stories and trending topics. And today, I'm not alone in the studio. I have with me Barrister Upoma. Barrister, you're welcome.
Thank you. Good to have you here.
How are you doing?
I'm good.
We're glad to have you here.
Same here.
So today, we will be discussing legal preparedness, document every adult should have. Because in the society today, we find out a lot of things are happening due to lack of preparedness when it comes to the legal part of it. So we'll be discussing that. For those of you who have or who are in the position whereby you don't even know what to do, like you don't know how to go about it, we are giving it to you for free today. We have a barrister in the house. So you're going to be hearing from him directly on how well you should prepare with legal documents before it is too late. Don't go anywhere because we have a lot for you to learn from. We have a lot to unpack. Just sit back, relax. Thank you. All right. Now, legal preparedness. Documents every adult must have. Now, we have an objective for this particular topic. Number one, we are trying to demystify exactly what legal documents are to help simplify it and help you understand what legal document. Number two, we are trying to remove the fear around legal things. A lot of people, when it comes, once you hear go and see a lawyer, is a problem. Everybody just gets scared of it. I want to help listeners understand what they need and why they need it and when to get it. And the last one, to encourage early legal preparedness, not emergency legal panic. That is the reason why we'll be discussing this topic today. So, Barrister, before we go ahead, let us understand what exactly is legal preparedness. When you say someone should be prepared legally, what exactly is it?
Okay, thank you. What exactly we are dealing with is making the general populace to be abreast and aware of what is expected of them per time regarding properties, investments, policies taken either in regards to life and any other thing that could come in that regard, making sure that there's legal backing to any of this, particularly when it has to do with transactions or businesses, investments, or any kind of negotiation and agreement. So whenever you have a party, a person or group of persons have the need to get into any kind of partnership or arrangement or agreement, then you have to put a legal backing to it. Because we live in a society where people can renege, where somebody can deny, where somebody can even contest a negotiation or a business or a transaction. So in order to put paid to all the uncertainties and unwanted irregularities, legal backing is needed to support these transactions, these agreements, or this partnership, whatever you call it. Once you give it a legal backing, once you give it that legal bite, then you're good to go.
All right. Now, a lot of people think that legal documents are for the rich. Why do you think that is a dangerous thinking?
Very, very dangerous. Because even the poor approach the courts, and sometimes they get what they don't bargain. The poor man, or even the poorest of the poor, can get his properties or her properties secured properly by a lawyer, by an attorney. It mustn't be a rich man who must go all the way spending money to have these things secured. No, it is not for the bourgeois, it's not for the rich, it's for the average citizen, it's for everybody who has a stake in any property, in any investment, in anything, howsoever be it. So let's demystify this narrative that it's only but the rich that can have access to legal documentation, legal advice, legal counsel. No. An average citizen, whether rich or poor, can approach a lawyer and then have some of these things done properly the way it should. By the way, There are widows who get legal services. There are widowers who get legal services. There is also what we call legal aid, where you can also get free legal services from the government. So you mustn't be for the rich. These things are there. The government have put these things in place to help the general public or the populace get support, get legal support in various ways that it can help them. So it's not really for the rich, it's for everybody. Even the man, the woman in the hinterlands, in the village, can approach a law firm, tell them what your problem is, tell them what your handicap is. And I think there are lawyers who are more than willing to assist you get what you want.
All right, thank you very much. Now, at what age would someone start thinking of getting a legal document for whatever reason? At what age? Is there a specific age?
Okay, let's take it this way. The From the point of view of our constitution, we are looking at who is an adult. An adult is someone, let me put it in layman's language, who is above 18 years. Because above 18, you can vote and be voted for. So taking that logical leap from there, we can say once somebody is above 18, 19, 20, you are a bona fide citizen qualified to own a property, to look for a legal documentation of any choice. And if you've not gotten to that age, then I would suggest that you don't. And if there's any reason why you should do that through your attorney, who knows how best to advise you in the circumstance. But once you are 18 and above, you can own property. If you can stand for election, if you can vote and be voted for, then I don't see anything stopping you from owning a property of your own.
All right. Now, the big question, which is regarded when it comes to family.
All right.
Now, a lot of people in families, a lot of parents, or let me just use it that way, don't prepare legally for anything. Now, let's take it like this. Now, in a family, when you come to a family where a man is very wealthy, he has the money, properties here and there, and all that, but did not actually keep any legal documents concerning those things now. Now, what exactly happens if this person dies or is incapacitated? What happens to the properties or the family?
But a very good question. Very good question. Now, let me come to this question this way. Let me romance it from this point of view. The need for legal documentation cannot be overemphasized. First and foremost, it makes for authenticity and legitimacy of transactions. People are phony. A lot of people you get into deals or transactions with are phony. What they can renege, they can tell you, I never knew when I said this. They can deny, they can contest. But once it is written down in simple prose, in dry letters of the law, the transaction is reduced, a lawyer puts his seal and signs, the parties are signed. That's what we call in law, res ipsa loquitur. It speaks for itself. You can't, even in law, it is a principle that you cannot vary the contents of a document by oral evidence.
Wow.
Difficult. Once it's written down and reduced in paper, and the court can feel it and see it, you cannot come back again to the court using what you say to vary what is written. It's not possible anymore. So if you fail to put down things, to get your legal documents, for those of them who are rich in a society, you have automatically put your entire family into chaos. What follows thereafter is total breakdown, anarchy, and of course, a general state of anomia that will create a precedence that will be difficult to control. To run away from all these unwanted and unwarranted developments that are there, that can distort, and disorient everybody, we suggest kindly, most honorable, that everybody, the rich amongst us, should try to do the needful. Whenever you are dealing with people, there are men, women, boys, and girls in that family tomorrow who may rise up to begin to ask, what did my dad leave for us? What, assuming our father is no more today, or my father has this, my father has that. How do we go around it? If there's nothing to show that these things belong to your father, what do you want the children to do? They will be at each other's jugular. Problems of this kind are myriad. If you approach the courts, a lot of problems like this fill the courts every day. Most of our big men fail to do what they ought to do when they ought to do them. And at the sick bed before getting the serenity of mind and the calmness and the quietness to get these things together is pretty late in the day. If you fail to, a wise man said, if you fail to prepare, you have simply prepared to fail.
Oh.
Failure in this instance would mean total breakdown, chaos, a general state of anomia that creates a precedence that will be difficult to control. I can bet you today that a lot of families that are in total disarray until this world comes to an end, internal enmity, just because the parent, the father, failed to do what he was supposed to do when he was supposed to do that. So we encourage every healthy parent to please, for the sake of posterity, for the sake of the children, and for the sake of the future, let them do the needful right now, that they are around, they are alive, healthy, bubbling, and are seeing these people growing up. You will never, don't take things to chance. Don't say, well, I know they are well behaved, they are well trained. No. Even the most educated can contest a property. Even though I've seen professors in the university who have come to court to ask the court to declare null and void the family partition, the way family partition the property, even when they were even involved in the partition. So it's not an issue of I believe my children are well trained. No, do the needful. Once these things are reduced in writing, once there's a document to prove that, look, I have this and this and this and this, and look at the way I want this thing to be distributed. Can I quickly at this point say this? If you put down things on paper, it is a supporting proof that there is a transaction. One, it's a supporting proof that there is something on ground that can be touched, that can be verified. That's a supporting proof that if you go to number 13 Wedra Road, there's a 2-story building there. That's 2-story building belongs to my father. It's in the document. If you go there, you will say that's a proof. And very importantly too, when you put these things down legally, it is a convincing evidence too that even if I'm no more, this is the way I want this thing to be administered. This is the way I want this thing to be shared. This is the way I want these things to be distributed among and amongst my children.
All right.
If they're not there, in fact, the man failed woefully.
Wow. Because I know there are a lot of families, like you said, that are in big, would I say, in confusion right now because the parents or the father did not do what he was supposed to do at the right time. Because I think there is right and there is wrong time. Most people wait until they're on their sick bed before they write a will. Some of them don't do when they're healthy. And I've seen a case scenario whereby the man wrote a will, but he did that when he was very sick. So after he passed on, they read the will to the children, and his son came up to contest that his father did not write that will in his right state of mind.
Mm-hmm.
And the lawyer was like, that is exactly what his father wrote. But the guy was like, no, his father did not write, because if his father had written that, his father wouldn't have wrote down what he wrote there.
You see, that was very, very, very correct. Well, definitely, there's no way we'll discuss this without talking about wills and the problems associated with it. You see, the reason why this thing should be done at the right time is because memory depreciates and fades. People die. The unexpected happens. Having this at the front of our mind, we can now begin to look at the reality of the day. It is important that these things are done the right time. If a man that is at the sick bed and a man who is well advanced in age, of course, you know what comes with age. When somebody is advancing in age, memories are not together, articulation is not profound. There are so many things that are coming and depreciating. If it is proven by if that man or that boy or that woman proves to the court, if he's able to prove that as at the time the father made this will, he was not in his right senses, the court will nullify the contents of that will.
Wow.
That is why you should do the right thing at the right time. In fact, look at the way I say it. Do things the right way, because you can also do the right thing the wrong way, which is still wrong.
Yes.
So we advocate and we solicit, as it were, that things be done properly, the right way it should be done, when it should be done. When is a man supposed to write his will? When a man is bubbling with life, when his articulation is together, when he's intellectually sound, when he's together, he comes to calls his children and calls his husband and says, "This is what I've done," and everybody sees that. Look, what I even advise most of these rich men that I'm connected to is, when you want to write a will, don't hide it. Call your children, share it amongst them. Call your Eze and the Eze's cabinet, share your property, let them see it. The way you are shared. Then when they go, call a that thing you have said before them, reduce it in writing. That'll be the chaos will disappear.
Yes,
anybody who comes to contest, they will say, we were there when your father told us.
Yes. But
now,
I think
yes, your father has told us and it's now written down on paper.
yes, but I think that's actually a good one because most people they just do it behind their family.
No.
And when they do it to their lawyer now, their children comes and wonder, why would my father write
such a thing?
Why would he give this part of his assets to this person? But if he had done it in presence of his children, anyone that has a question to ask will do that.
Right, good.
And they will settle everything.
It's settled, it's gone. Disputes are settled. Contentions are thrown overboard. Nobody can come up and say, hey, I wonder who is sure my dad did this? My dad did this. Who told him? He's there.
Yes, because he did it in front of everyone.
This is what I do with my clients, and I'm doing it today.
Wow, that's beautiful. All right, let's quickly go on a short break. And when we come back, we'll continue with this whole discussion. Thank you. Welcome back from that very short break. And trust me, it has really been a very, very interesting and powerful discussion here in the studio, and also an eye opener because there's some things I don't know legally, there's some things I don't know, I don't know. So Barrister here is actually opening our eyes to a lot of things. Now, before we went on that short break, we were talking about will, when one should do it, doing something, doing it at the right time. That was what we were discussing before we went on that short break. So quickly now, Barrister, let's talk about why some people fear to write wills. Why are they afraid of writing a will?
My dear, we live predominantly and dominantly in an ignorant world. People showcase a lot of ignorance. They're not aware of what they're expected to do. Unfortunately, still staying in that state up till now is very, very worrisome. So we can say ignorance of the legal implications of not writing a will could be a reason why most of them don't write. Except they will now find out the necessity when the problems have started. So, and again, is when we appear to take things so light for granted, it doesn't matter. Procrastination is another problem. It's a top factor. I will do it in 2024, up to 2027 if not done it. I will do it in 1990. This is 2025 if not done it. We keep procrastinating. We are told that procrastination is a thief of time. So what you failed to what you failed to do at the right time will turn back in time to haunt you.
Oh.
So these are some reasons why a lot of people fail to write this will when they're supposed to write it. And can I say the fourth one? We think we are in control when we're not. Why? Because the unexpected can happen. You see a man today that is full of life. You discuss with him. We even had to take a lunch together. There's no sign that something is wrong. Or to a greatest chagrin, tomorrow, first thing the next morning, you are told he's gone.
Yes.
The unexpected. We're not in control of anything. Nobody's in control of anything except God.
But some people will ask you, why would you ask me to write a will? Do you wish me dead?
Fine, that's the total ignorance. Total ignorance of the fact that something can happen. There is the unprecedented, there is the unexpected that can come and take you. When it has happened, it has happened. The chapter is closed.
Wow.
So when someone, you see, that tells you the kind of milieu or the kind of environment that we find ourselves. People here are not quite very, very knowledgeable, especially when you are surrounded with people who don't have basic understanding of the currency of the time. Wow. And we tend to borrow antiquated reasoning, outdated suggestions, and things that cannot help us. You see somebody telling you something that happened in 25 years ago, which is not compatible with what is happening now. For example, sometimes most of us that have grandmothers, the scientists, let's go a little of science. They say minimize your consumption of red meat. For example,
okay.
You see a grandmother telling you that his great grandfather ate red meat until he died. That era and now is not the same. There's so much awareness, and the kind of thing that happened that time, most of them are not happening now. So now, taking that analogy, we can find out that people tend to suggest to you, there's no need for that. Leave it. The family will take care. Leave it. Don't bother. When you start thinking about it, you bring death. is antiquated reasoning, outdated reasoning. So these are some of the factors militating against, the current move, the current legal move of the time that is required for us to get these things in place at the right time. Let's not forget, what you fail to do at the right time will turn back in time to haunt you.
All right, I think I'll pick that up. Okay, now in Nigeria currently, because since we're talking about legal documents here. What happens when someone dies without a will in place, especially a wealthy man who has assets here and there? What happens when he dies without a will in place?
That's what we call in law. He died intestate.
What does it mean?
He died intestate means he died without a will.
Oh.
Okay, let's take it this way. Mr. A is a multi-millionaire, multi-billionaire. He has assets. He has all kinds of things, both cash and liquid. And then he didn't write a will. He died. He died intestate. Now look at what's going to happen. The confusion he will create will be so much because the court will now say, since he didn't write a will, share the family property according to native law and custom.
And that's going to cost a whole...
That's where the problem is. Now, let us assume the man has 3 wives. And those 3 wives gave him children, male and female. Who is going to be the first son? Who would agree that he's a second son? Who will agree that he's a third son? The first wife gave birth to a male child. The second wife gave birth to a male. The third wife gave birth to a... Who is going to take the subordinate position? All of them will come out and tell you, I'm the first male.
Oh.
I'm the first. We see that it is happening before us today. But assuming the man wrote his will. My property at number 14 Bono GK is for Samuel. I call the name Samuel Jemazi, maybe, or Samuel Okore, for example.
Has been stated clearly.
It's clear on some paper. You don't. Once it's shown to the court that the man wrote this will when he was bubbling with life in sound health and without defect of any kind, there's nobody can controvert that. But if you fail to do that, the court will not tell you, do it according to native law and custom. I know what will happen. Even if after sharing the thing according to native law and custom, killings will start.
Exactly.
Maiming will start. All kinds of things will go on because some of our native laws and customs, we are still having problems with it today. If the Eze has interest in that family, some of the Ezes will take sides. The cabinets will take sides. The community will take sides. But as these things are dispensed with, if they are written down on paper, Eze will fear to interfere with what is written down. The community will interfere. If you do that, you know the consequences. There will be consequences if you interfere with what is written down on document.
All right. Sorry, there's this question that I want to ask now. Now, in a situation whereby someone wrote a will, he wrote this will when he was really bubbling with health. He was very healthy. And the will was read out to the family after he passed on. Can anyone in the family contest that will for one reason or the other, despite the fact that person has written that will when he was in sound mind?
There could be, I'll give you an example. There could be an occasion or an instance where a valid will, a will can be contested. If it is proven, because in law, he that alleges must prove. If you allege something, there's a responsibility on your shoulders to prove it. Don't just come and say, this man is a criminal. I want the court to kill him. No. You can say there is an element of, there's a degree of fraud in this will. You have to prove it. Probably your father was induced, or the lawyer was bought over by the first son, second son, first daughter, or any of them. And you have supporting proof to prove that, look at, this is what happened. If the court sees it, it can nullify that will. Yes, a will can be nullified. A will can be thrown out where it will find a degree or element of fraud, where there is an unsound mind, like we've said before, the man is not in good state of health, where it is all proven that the man who wrote the will is not the man who should have written the will in the first place. I get what I'm saying. But remember, don't forget something. You must prove to the court. For you must prove that this is what happened. Look at how it happened. The court will come and verify it. If these things are not proven and verified, forget it. The argument is watery. You cannot hold.
In case whereby you don't have evidence to back up your claims.
No, you fail.
There's nothing.
You fail.
Okay, quickly. Thank you very much for that one. Let's quickly talk about power of attorney.
All right.
Because I hear that a lot, POA or something. Now, what exactly is power of attorney? When someone says, okay, I'm giving this person power of attorney, what exactly does it mean? Make it understandable to us in the layman language, not the law and the lawyer.
Okay, let's
understand it.
okay, but let's say, Gloria, you are rich now. You have a lot of money. You bought 10 plots of land, for example, and out of the 10 plots, you want to give gospel 2 plots of land. What you're simply saying, I'm going to give gospel power of attorney. What that means that I'm conferring my right, my interest in the 2 plots which I have by law. I'm transferring those interests to gospel,
Okay.
so that he will now become the man that will exercise those rights on my behalf. I'm appointing him as my donee. Look at power of attorney means I have appointed him. Power of attorney. I have appointed so and so on my behalf, in my stead, to do so and so thing on this property, which I myself would have done, assuming I'm there. I'm giving him that power of attorney. Take the land, take it, exercise the right, enjoy ownership, enjoy possession.
Okay, so if that person is unconscious or is dead, the person that holds power of attorney becomes second in command or what?
No. You are the one. Okay, let's say. Let me put it in a better way. If A has a land, Mr. A has a land, and Mr. B wants to buy, Mr. B will approach Mr. A. I'm interested in your land. If they agree, if there's an agreement between the two of them, Mr. A will say, okay, if it is 1 plot, this land belongs to me. There's legal right. I have legal right. I have equitable right in the land. I'm transferring those legal and equitable rights to you now as buying. Now, I'm appointing you as my representative in this land, as a donee. Now, as I'm transferring my interest and my title to you, you are now empowered. The way I was empowered when I'm in control to now take this land, use it, and do whatever you want to do. As if when I'm the owner, I would have used the land to do the same thing I wanted to do with it. Now you are transferring power. You see, that's why power of attorney. Look at power is being transferred to an attorney. The person that you are selling to becomes an attorney. You are transferring the power you have in that property, your interest, your both legal and equitable interest. And also you are transferring title, most importantly, to this person. And the only thing that qualifies him to enter into that land and use it is the document called power of attorney. He can bring that document to me and say, you signed for me, and there are witnesses that I paid you 100 million and you gave me this land. This land belongs to me. This is my power of attorney.
Okay. All right. You said now he can bring the document and there are witnesses now. My question now is, okay, let's say Mr. A and Mr. B now, for instance, now there's a transaction between both of them. And they got the document and both of them signed it. Now, if there is no witness there when they sign that document, is that document legal? No. So there must be a witness.
There must be a witness, not even a witness. 2 this side, 2 this side, 4.
Wow.
If see, you see, this is why I say the property must be done the proper way. If A is selling a property to B, the law says you will sign for him that you have transferred title in the presence of witnesses. You know why? If tomorrow you're no more, and your children comes now to contest that land, no, this is our father's land. Witnesses will know where there when your father signed.
Wow.
You get the point?
Yeah.
It's clear. You have your own witnesses who will stand for you. The man selling, the donor, we'll call him the man selling is the donor. The man buying is the donor. The donor also have his witnesses. If in the event that both the man selling and the man buying dies, those witnesses will be alive. Say, we were there, we signed for him when the transaction took place. Look at our signatures.
Wow. Now, in a case whereby someone is unconscious or someone dies, who acts on their behalf? Who will stand on their behalf? Maybe there is no, what is it called? We are talking in regards to this power of attorney.
Okay.
In a case whereby maybe someone is dead or someone is unconscious and there's nobody to stand or do things on who acts on his behalf?
Okay. Let me put it this way. If A is selling a property and he's on death row, he's unconscious, and he wants to sell, probably to raise money and do 1 or 2 things. Now, in that circumstance, in that instant, he can reason. Let's take he's unconscious. That's all he can do. Huh? In that instance, then the family should get a lawyer. Maybe if the son is available, the son can come. Call elders who are around, who can also attest to the fact that this man can no longer talk. He has an adult, a son of 20, 25 years, who can say, "This is my father's land. I want to sell on my father's behalf." That's okay. It's permissible. It's permitted at law. Somebody can deputize for him on his behalf if it is proven that he's incapacitated at the moment. So there must be somebody to deputize. There must be somebody also to say, yes, he's not around. He cannot do this. There's no ability to do this. We can help him do this, get this thing done. So the law permits such to happen. It's like saying when you have an illiterate person who wants to sign a document, he cannot sign. The law says, get him a jurat. Get him somebody that can help him sign.
Wow. Okay. Before our time is past, let me ask this question before. Let's say now, for instance, now a woman who lost her husband.
Okay.
Who lost her husband. And let me say the man has some certain amount of money in his bank accounts. But due to maybe things happen, unfortunately, it was not planned and life happens the way it happens. And now, how will she be able, maybe there is no documents or anything stating the fact that she can gain access to his money or anything. How will she go through that procedure?
If it is a joint account.
No, a personal account.
Okay, personal account. Yeah. The only option available for the woman is to get to what we call letters of administration.
Okay.
Get to the probate registry, fill the requisite forms, all right, state exactly how much is in there in the document, pay the fees, and then when the letters is endorsed by the chief judge, it takes some time. When it's out, it will empower you to go and take that money. The bank will respect it.
What if she don't know the exact amount there in the account?
Then when you now approach the bank and tell them you are filing for letters of administration, you want to have access to what is in your husband's account, it will be given to you.
All right. Thank you very much, Barrister, because I believe we've learned a lot from this segment. So quickly before we go, what do you have to say to young adults out there who are, most of them are actually making wealth but not securing their wealth legally? What do you have to say to them?
My advice to everybody listening today: take advantage of this this information we are sharing on air and do the needful. Secure your properties, approach your attorney, itemize them and put them together. Where it's necessary, go for your C of O, or if you cannot go to that point, register your power of attorney. And then also protect your land, protect your properties, and again, protect your life as well. Take up a life insurance. Stop parading with expensive phones and gadgets that will not afford you anything. Go and get a life policy that if anything should, in case anything happens somewhere, you have your family or you will have somewhere to fall back on. It's important. Please, everybody should take advantage of this information and rush out and do the needful. The unexpected can happen. No one is in charge except God.
Thank you very, very much for that. So, our viewers out there, you've heard from our barrister here. He has given us a lot of insight on what legal documents means and the ones that are very important that you should have as a person. Things you should do, when to do them, and how to go about it. So until we come away next time, please do well to follow us on our social media handles on Facebook, follow us on TikTok, follow us on our Instagram, follow us and subscribe to our YouTube channel where you watch our full episode. And please leave your comments. If you have any opinion or something you want to share, we would love to hear from you. Just drop your comments and we will get back to you. I remain your lovely host, Gloria. Until we come away next time. Bye for now.